I'm Joseph Fetterman. I'm a criminal defense and family attorney with Worth Law Office here in the Oklahoma City office. I'm hired to help somebody with their first time having a criminal case. That's like bigger part of the battle is they're always confused at like what happened, what are the charges stemming from, what do I do now with the charges? But even when you explain it to them, if you take a lot of care in explaining the process, like okay, today's an arraignment. What we're going to do is we're going to show up. For Oklahoma County, prosecutors won't show up. So you're just in there with the judge. You're going to get a packet of information that says you're being accused of this thing on this date at this time, and you were arrested by these people, and this county's pressing charges for this thing. And so it's just a date. Now that happens real quick. The attorneys show up, we get your date, we walk you to the door, we say, all right, we'll see you on this date. And the client is very confused at what just happened and why did they have to pay money for that to happen. So to slow them down and let them know that, hey, on this date, we're going to get this paper. The paper is just going to say a very brief and very overview of what the charges are and just the probable cause that led them to believe that the client may be associated with this act in some way. And then our first date. That next date is super important to me. I look forward to that date the most because that's when you get to meet the prosecutor that's assigned to the case, and they don't know what's going on. They got the same thing on their end. Here's a piece of paper with an overview of what might have happened and how they might have been involved in this thing. And now they have to start digging into how do they prosecute the case, just the same as we have to look into how do we defend the case. But that's our first time to get to meet the prosecutor. We get to meet the special judge that's going to hear it, and all the way up into the preliminary hearing, um, which rolls into that next setting, which is you'll have these preliminary hearing conferences, which is the opportunity for the prosecutor and us, the criminal defense, to get together, collect the evidence, share the evidence with each other to say, hey, we don't need to have a trial over this. This is what happened. Let's see if help is more appropriate. Let's see if we can negotiate this to get, in the best interest of justice. Not everybody needs to serve a life sentence. Um, if your client didn't do anything, then you have to bring that up to the prosecutor. The prosecutor has a duty to bring exculpatory evidence to light. Also, if they have evidence that they've come across that wasn't your client, if we were to stick with the DUIs, oh, by the way, your client wasn't the one driving. There was a mix up in driver's license. We just sent it to you. You were the owner of the car. Okay, well, we weren't driving. So that means it wasn't us for the DUI. That's exculpatory evidence. And that's what comes out when we start investigating what really happened with these charges, right? So that usually happens and works itself out in the preliminary hearing conferences. And they preliminary hearing. Sorry, but in that stuff works itself out. We get that communication going, and you can try to prevent going to a preliminary hearing. Now, not all the time. If the state's position doesn't change, regardless of what we have learned in that time frame of those hearings, if the prosecutor's office is content with having a preliminary hearing, the defendant gets to have the choice of do we want to put on a preliminary hearing and see where the probable cause is and make the prosecutor in front of the court, in front of the defense counsel, um, prove to a judge that there was probable cause, that there's enough information and evidence that would support that a jury needs to hear whether or not this person committed the crime. Well, then we had to have a preliminary hearing, and there's a ton of different thoughts and strategies on what to accomplish, but that's a big step. Generally speaking, our contracts are we get to that date, and that's when the client needs to retain us for preparing for a trial, or if they want to conclude our services at that time because it's like a waypoint. It's not a not looking back waypoint. Like you can still change your mind, but really from that point on, it's focused on preparing for a trial. You're going to go the distance. This is going to be a knockdown fight, where you have to prepare every inch, and you have to make the prosecutors prove every inch. But that kind of detail intimidates clients because At this time, it might be 4, 5, 6 months removed from the date of the accused situation, right? And their memory's starting to fade, and their proof has been misplaced. So it's very intimidating. But for the attorney to be able to explain to them what is important, what is relevant, what we do have, what we do not have, all that stuff is super important to the process. But explaining it to the client is important because it's ultimately their decision. They rely on me to provide that counsel to them. Hey, this is our shot. This is that. Here's what we have. Here's what they have. But they ultimately hired us because they don't know. They know what happened. They know what proof they have. That's never been a question. They don't know what's important to the judge, to the jury. They don't know the process. So they want you to be able to keep collecting that information, but keep explaining it to them in a way where they can make that decision where they can deal with it for the rest of their life. They are the ones that have to deal with that. So getting that prepared and explaining that all to them is what I see is their biggest concern when they hire us is what is going on and what is next. If you or someone you know needs an attorney, reach out to Joseph Fetterman with Worth Law Office here in Oklahoma City. Our phone number is 405 694 4609.